Hello and welcome. You're watching To The Point. Reports that the United States could have spied on the Indian government and the Bharatiya Janata Party have inevitably hit the headlines. But how serious a matter is this? How should the Indian government respond? And what can we expect from the American side? That's the subject in part 2. But first, the big controversy surrounding the government's handling of the Supreme Court Collegium's recommendation to make Gopal Subramaniam a Supreme Court judge. Tonight, we should examine key questions that have not so far been fully answered, and some would even say fully understood. For instance, why is segregation considered improper? Has it happened before? How damaging is the Chief Justice's criticism of the government? Was Gopal Subramaniam right to go public with his 9-page letter? Did he act in pique or behave honorably? Are his implied criticisms of the court justified? And finally, did the government reject his name because of his role as amicus curiae in the Sohrabuddin Sheikh case? In part 1, we shall try and answer all those critical questions. And now joining me for the big discussion on the Gopal Subramaniam controversy are 4 of India's top lawyers. They are former Attorney General and Solicitor General Soli Sorabji, former Vice Chairman of the Law Commission KTS Tulsi, and 2 of India's most senior and best-known Supreme Court lawyers, Aryama Sundaram and Dushyant Dave. Soli Sorabji, let's start with the government's response to the Supreme Court Collegium's recommendation to appoint 4 new judges to the Supreme Court. 3 names were accepted and warrants issued for their appointment. The 4th name, Gopal Subramaniam, was sent back to the Collegium for reconsideration. In your eyes, is this sort of segregation acceptable or is it improper?
Karan, I don't think the segregation in itself is improper because of 3 names are approved and there's no dispute about their appointment. Why should they be held up till the 4th one is being looked into by the Collegium in light of the material sent by the government? I think what the Chief Justice really was upset about is that he was not informed, or rather the Collegium was not informed about the proposed segregation. That I understand. They should have informed the Chief Justice and not kept him in the dark about this. But intrinsically, I don't find it impermissible or unconstitutional.
So if I understand, if I understand your view correctly, there's nothing intrinsically wrong with the segregation, but perhaps as a courtesy, the Chief Justice should have been informed about this in advance. Is that a correct summary of your view?
Correct.
KTS Tulsi, let me put it like this. Given that the executive has the right to ask the Collegium to reconsider, what's wrong in accepting the names they have no problem with and separating the names they have doubts about and sending those names back for reconsideration? As Soli Sorabji put it a moment ago, why hold up the names you're happy with till a final decision is taken on the other names?
That's true. I entirely agree with Soli. There's no reason for the names about which there is agreement between the Collegium and the government for them to be held back. Why should the judges not be in position and vacancies persist even for a day more than necessary? And if there is no controversy, those names should have gone ahead. But the only problem is that the Collegium ought to have been informed. But that problem is also compounded by the fact that in the meantime, Mr. Gopal Subramaniam reacted very strongly and made accusations against even the Collegium. Collegium had not yet reconsidered.
Absolutely.
And he said, I've been let down by the Collegium.
Can I stop you there? Let me stop you there for a moment, Mr. Tulsi. Let's take up Gopal Subramaniam separately in a moment's time. Let's first concentrate on the segregation that happened. I promise I'll come to Gopal Subramaniam separately. Am I right in understanding that your view is very similar, therefore, to Soli Sorabji? There's nothing intrinsically wrong with segregating one name, but like Soli Sorabji, you believe, as a courtesy, the Chief Justice should have been informed of this. Have I understood you correctly?
Absolutely. Absolutely.
Mr. Sundaram, let me put it like this. The government's position, it's not formally and officially articulated by the government, but it is certainly being made known to journalists through sources, is that there is inherently segregation involved when the government exercises its right to ask the collegium to reconsider one name or more. Therefore, the government believes that the Supreme Court Chief Justice perhaps doesn't even need to be informed, because that is inherent in the government's exercise of the right to ask for reconsideration. Would you accept that that one step further actually makes logical sense?
Certainly not. I'm afraid that I am not entirely in agreement with this issue that segregation is permissible as it stands. The fact is, a de facto segregation may take place because the government approves of certain names of the recommendations which have been made and may have second thoughts about certain other names. The procedure to be followed then is the entire list is sent back with the comments which the government has about a given name and saying the others are fine. And then if the Supreme Court collegium wants, they can segregate and send back 3 names and hold up one while they reconsider that. Or they can consider the matter and either drop the name, or if they so want, send all 4 names together. But I do not believe that it is for the government to unilaterally say these 3 warrants are issued and that is not.
Can I interrupt and put this to you? Why does it make such a critical difference whether the segregation happens at the level of the government's response or whether it happens at the level of the Supreme Court's response to the government's response? Why is it such a critical factor at which level the segregation happens?
Because for one thing, it is the Supreme Court which sends a list, and it's for the government to consider the list, and if it disagrees with the list as sent, to then inform the Supreme Court what its disagreement is, and then leave it to the collegium then to decide and consider it, and then send their list back.
Okay.
Secondly, this could create practical complications. Karan, for example, take an example. You have 4 judges, one is senior most in that list. The segregation is done, 3 are appointed, and the Supreme Court collegium once again sends that other name back. Now that person's going to go down in the seniority list because instead of being the most senior, he becomes the most junior of the lot because the others have already been elevated.
Just a moment.
This is one aspect.
But that aspect
there is one other aspect I want you to look into.
Permit me an interruption. That aspect is an intriguing one because the Chief Justice seemed to suggest that segregation affects the independence of the judiciary. Most people thought that when he talked about independence of the judiciary, he was actually talking about how judges are appointed. You're now interpreting it into a fact something to do with the seniority of the judges appointed. Surely the seniority of judges appointed is not really an issue of great concern.
Aspect.
It doesn't deal with independence.
I think Mr. Sorabji will be able to clarify on this, but it is my understanding that there was a memorandum of understanding between the government, between the executive and the judiciary, after the judge's case where this was decided as to what the appointment procedure was.
Let me go back to
that if a list is sent,
just
if the government has any comments on it, they send the list back with their comments.
Let me go back to Soli Sorabji on that point. Let me go back to Soli Sorabji because you've raised a factual issue. Let's see if it can be clarified. Mr. Sorabji, as someone who was both Solicitor General, Attorney General, and someone who's been involved in the legal profession perhaps longer than anyone else on my panel tonight, is there a memorandum of understanding between the executive and the judiciary that followed the 1993 judgment setting up the collegium system of appointment, which ruled or which has set a convention that in fact segregation won't happen and that all the names are sent back together without any differentiation? Is there such a memorandum of understanding?
No, I'm not aware of it. As far as I'm concerned, I'm not aware of such memorandum of understanding. There may have been possibly some practice, but I frankly don't understand this. I don't think the Chief Justice has regarded this as an assault on the independence of the judiciary. The Chief Justice was legitimately agreed by the fact, okay, why wasn't the collegium informed? That's all. To that extent, there may be some impropriety, but there's nothing unconstitutional about it.
Let me bring you in on that particular issue, KTS Tulsi. Newspapers, and in particular today's Indian Express, claim that we've actually had instances of segregation in the past. The Indian Express points out that in 2009, the collegium recommended two names, Justice Swatantra Kumar and Justice C.K. Prasad. Justice Kumar's name was cleared immediately. Justice Prasad's name was only cleared after a few months. If segregation was acceptable in 2009, how has it become unacceptable or improper in 2014?
That's true. According to my understanding, there is no cut and dried policy or principle or procedure. The procedure adopted by the law minister normally is that if there is a reservation on a particular name, they would they would inform the Chief Justice either by personally calling on the Chief Justice or even sometimes on telephone. I've seen this happen even on telephone. The question is that the collegium is kept in the loop, but why should there be a delay in the appointment of judges with regard to which there is complete unanimity between the collegium and the government? So that is the principle on the basis of which this file is sent up. If at all there is any breach of courtesy or a propriety, that's all that may be there to it, but it doesn't in any manner affect the independence of judiciary, because government is not alien to the process of appointment of judges.
We are now slowly, Surabji, talking about the matter of segregation, not on the grounds that segregation is improper, as the Chief Justice says and as R.M.S. Sundaram has himself also claimed. We're talking about segregation on the grounds that in fact it was a lack of courtesy to have informed the Chief Justice in advance, which, as Mr. Tulsi pointed out, is a much lower order of concern. Let me add to that something that may have compounded the problem further. It's widely believed that in this instance, it was leaked by sources that when the segregation of Gopal Subramaniam's name happened, the Chief Justice had somehow been informed and had orally, it said, agreed to it. That is something the Chief Justice clearly disputed and refuted yesterday. He said this had happened without his knowledge, without his consent. Were leaks that created the impression that somehow the Chief Justice was on board a compounding factor and a terrible mistake?
Sorry?
Are you asking me?
I'm asking, sorry, Sarabji.
Mistake on whose part?
Were those leaks a mistake on the part of the government, that they leaked that somehow the Chief Justice was on board and had orally agreed to segregation when clearly he had not?
Well, I don't think so, but where's the mistake? There's no such practice. As was pointed out in the other case about Chief Justice
Swatantra Kumar and C.K. Prasad?
Yeah, exactly, but that shows that there's no such practice. Only thing is, as I said, matter of courtesy, matter of propriety, they should have informed the collegium of the Chief Justice and not done it unilaterally.
Okay.
That's the highest I'll say.
Let's move on, R.M.S. Sundaram. Let's move beyond this question about whether segregation is proper or not. Let's move beyond whether the government compounded the problem by suggesting through leaks that in fact the Chief Justice was somehow on board with the idea of segregation. Let's move now to in fact the comments the Chief Justice made. He said quite clearly that he objected to the segregation. He said it is not proper. How embarrassing is it for the government when such strong criticism is levelled at the government by a sitting Chief Justice of India?
Extremely embarrassing, and I do not believe that the government expected this reaction. It is a fact that the Supreme Court has over the years become a very, very, very powerful institution. There have been complaints from the government side time and again that the Supreme Court is treading into policy matters. I see this as something far more. This was actually an attempt by the government to exercise a certain power to show that the Supreme Court was not the absolute only single deciding body, and the government itself had a big say in it. And I believe that is why this whole move was made to somehow take an independent decision, go into the segregation, go ahead and say warrants issued for 3 of the judges, and so far as the 4th was concerned to say no, and to depart from what the procedure was. And I believe it was an attempt, and it is an attempt by the government to say that the supremacy of the court amongst the three institutions cannot be seen in that way, and that the government has a right in the appointment of judges, which it will exercise in future. And I think it's really an emphasizing or a trying to put their toe in and to make it very clear that they will have a say in the appointment of judges. And I think there's far more to it than
let me stop you there. Let me stop you there, Mr. Sundaram. Let me bring in KTS Tulsi. You've just heard KTS Tulsi, a wider interpretation by RMS Sundaram of this segregation. Whilst you and Soli Sorabji believe there's nothing wrong in segregation, what you've heard RMS Sundaram say is that in fact he believes the government was trying to take over the role of the Supreme Court in appointing judges. It was trying to impose itself in the process. Given that you strongly disagree with that interpretation, now is there a need for the government to justify or at least clarify why it segregated that name? Does the government need to speak up and explain to India, particularly because the Chief Justice has objected so strongly to that segregation?
Well, they may explain, but that will do more damage to the nominee. And that is why circumspection is required. All the allegations which are contained in the report of the Intelligence Bureau or the CBI, etc., they are not verified allegations, and to some extent they may be either exaggerations or misinformed also. So they may not be entirely correct. But if they are brought in to the public domain by the government officially, it will cause irreparable damage to the reputation of the nominee. So I don't think that we need to have a public spat about this. But the government is not alien to the process of appointment. In fact, Dr. B.R. Ambedkar had said very categorically in the Constituent Assembly that we are not willing to leave the final say about appointment of judges to the Chief Justice. The power of appointment must vest with the President, and the President will exercise that power on the advice of the government of the day. And therefore, to say that very well, there is a judgment of the Supreme Court and consultation has been read to mean concurrence, but it doesn't mean that government has no role at all.
Absolutely.
And the procedure, if it is not laid down, any procedure can be adopted which is fair.
Absolutely. I take your point that the government has a role to play, and that is in fact a counter to the point made by RMS Sundaram that the government is usurping the role of the Supreme Court. But let's move on. Let's now come to Gopal Subramaniam. Soli Sorabji, first of all, having promised the Chief Justice that he would not do anything till the 28th of June when the Chief Justice was due back from abroad, and that he would keep quiet till then, Mr. Subramaniam A, changed his mind on the 25th, B, he then withdrew his name, and C, he made public a 9-page letter. In your eyes, was this a rash response by a gentleman whose pride understandably was affected by what he was reading about himself in the papers, the motivated leaks about him being unsuitable? Or do you think it was the honorable thing for him to do, to withdraw voluntarily? Which do you think it was?
Karan, I won't put it in any particular category. I know Gopal Subramaniam. He was my first junior. I also know he's a very emotional person. He's sensitive. In fact, I spoke to him from London. I said, don't make any statements, don't go to any news channels, but it was too late. His 9-page letter was in the public domain, some part of it. What I feel is, I understand, I think he made a mistake. There's an error. He should have retained his trust in the collegium, because even under the present law as it exists, the government has the right to tell the executive, well, we have considered your objections, we maintain our initial recommendation. In other words, ultimately the collegium, the judiciary has the final word. Why did he not wait? Why did he not trust the collegium to do that? He rather preempted the whole thing, preempted it. If he hadn't, well, I can't say with certainty, but I'm almost certain the collegium would have reiterated its recommendation about Subramaniam, which the government is bound to accept under the law. Thereafter, the supremacy of the judiciary would have been established, and my friend Gopal Subramaniam would have been on the bench.
RMS Sundaram, let me pursue a question about Gopal Subramaniam with you like this. In his letter made public, Gopal Subramaniam says that he has reliably learnt that the collegium was not asked to reconsider his name. Secondly, he says he has reliably learnt that segregation was made without the knowledge and the consent of either the collegium or the Chief Justice. Those are points he makes himself in his letter. Therefore, having made those points, shouldn't he have waited to see how the court responds to the government's segregation before withdrawing his name?
The fact of the matter, Karan, is that so far as Mr. Gopal Subramaniam deciding that he wants to withdraw his consent, it is a completely personal decision. But there is one thing which happened. The offshoot of this was that it deprived the court its opportunity of exercising the right the collegium had and proceeding with it and going further. But we should also not forget one thing. If it was merely a case of the list being sent back by the government, stating that they had a certain objection so far as one of the names was concerned, the court would have considered it and then sent back the recommendation, whether it's yes or no. However, in this case, the issue of segregation had happened. It had already been segregated. And I think his protest was to that. As to whether he should have made his protest so public or have released the newspaper, released the letter, that's a totally different issue.
Okay.
But I'm on the issue as to his withdrawing his consent was a purely personal decision. And I think from what I can understand from the way his letter read, it seems to stem from the fact of the segregation.
Well, actually, I'm going to put that
And
question
not from the fact that the government had any misgivings
I'm
and
going to
was
put that
sending back
question
the
to
list.
KTS Tulsi, because KTS Tulsi, his letter makes it clear that he's not simply upset about the segregation. His letter also has some implied criticism for the collegium and the Supreme Court's response. I'm going to quote that letter. He says, "I am unable to dispel the sense of unease that the judiciary has failed to assert its independence by respecting likes and dislikes of the executive." Given that he did not give the collegium a chance to respond to the segregation, that he preempted the collegium's right to insist upon his name by withdrawing his name, has he now got a right to be critical of the court? Because he's clearly critical of the court in that letter.
That's right, and I really think that he has put those words in past tense. And on that day, the matter had not yet gone back to the Chief Justice. The collegium had had no opportunity of deliberating on that issue, and he still said that I feel let down by the judiciary or by the collegium. I don't know. Perhaps this was an overreaction, and I don't agree with Mr. Sundaram that it affects the seniority in any manner, whether the segregation takes place before or after, because the seniority is determined by the order in which the oath is administered. And normally, the oath is administered in the same order in which the names are sent by the Chief Justice to the government. And the same order of seniority is maintained. Nothing happens if the warrants are, if one list is cleared and if the oath has not been administered.
I take your point. I take your point.
Have affected seniority.
I can see that R.M.S. Sundaram is nodding his head in disagreement, but I'm not going to go back into that point about seniority. That's an issue we've discussed, and I think it's a somewhat technical issue anyway. It's not the key point about the segregation. I'm going to go forward and concentrate instead, Soli Sorabji, on Gopal Subramaniam. Because in his letter, Gopal Subramaniam goes one step further. He says in his letter to the Chief Justice, and I'm quoting, "I trust you and your colleagues will undertake suitable introspection." Has a situation arisen where the collegium or the Supreme Court needs to introspect? Or is the need for introspection actually something that Subramaniam has to ask himself? And does he need to ask himself whether he acted rashly and impetuously in withdrawing his name and perhaps in the end doing himself an injustice? Who needs to introspect? The Supreme Court or Subramaniam?
Well, you're asking me, Karan?
I am indeed. Yes, Soli.
Yeah. Well, look, his statement I can't understand his unease. But why did he assume that the collegium would accept the report sent by IB, and the collegium would not reiterate its original recommendation? Why did he come to the conclusion that the collegium would not do that? That wasn't fair. He should have given an opportunity to the collegium to really exercise its right of rejecting the government's objections and say, no, we affirm it. That's a short point. But he prevented that. He preempted it by his own act of withdrawal. Maybe he was under emotional pressure, maybe that, I'm not blaming him, but the fact is that withdrawal, what did the collegium have to do then? Where's the option to the collegium?
Okay.
What can he do when he's withdrawn it?
Arima Sundaram,
He
I'm going to
brought
come
about
to
the
you.
situation by his own act.
I'm going to come to you, Arima Sundaram, for my last question. And it's to do this time with the allegations that Gopal Subramaniam has apparently leveled against the Modi government. Again, I'm quoting from his letter. He says, I have reliably learnt that the Ministry of Law and Justice initiated an inquiry after 15th May 2014 with a clear mandate to find something to describe me as unsuitable. And what he seems to be claiming or suggesting is that he was targeted and segregated and refused the post of judge at the Supreme Court because of his role as amicus curiae in the Sohrabuddin Sheikh case, where Amit Shah, a possible future president of the BJP, is an accused. Is that, in your eyes, a justified allegation?
Well, let me put it this way, that the fact of the matter is that Gopal Subramaniam was the amicus, that Gopal Subramaniam was very, very stern in many of the comments he made. And I do believe that his feeling this had some part to play cannot be called totally unjustified. Equally, I believe, and I agree completely with Soli, that he deprived the collegium of their chance to consider the matter and to act on it by doing what he did. And in fact, if he had not, the judiciary would clearly have been able to establish its independence and its rights in this matter. And to that extent, I do not subscribe to what he did.
Okay.
But so far as the apprehension that this could have lurked in the mind of the government against him, I don't think that apprehension is something which too many people will dismiss very lightly.
Okay.
And I do believe that a lot of people would feel, yes, it is possible.
Let me very quickly come to you on that, KTS Tulsi. It's not just an apprehension that lurks in the mind of Mr. Subramaniam. To be honest and to be fair, it lurks in many minds. And certainly it's one that the press suspects could be the real motivation for the rejection of Gopal Subramaniam's name. Therefore, do you think it is now incumbent on the Modi government or on Ravi Shankar Prasad to not just clarify, but perhaps convince people that Gopal Subramaniam's name was not rejected because of his role in the Sohrabuddin Sheikh case?
The more you try to convince the people that it was not rejected for that reason, you will bring in other dirt. And I don't think that this kind of a spat is really in anyone's interest, much less in the interest of Mr. Gopal Subramaniam. You know, if he had become a judge, it would have been a huge sacrifice. Any lawyer of that stature makes a sacrifice by accepting the request to adorn the bench. If he hasn't become, he hasn't lost anything. I don't think that there is need for him, and let him not further inflict an injury on himself.
Okay.
By expecting that now the law minister will tell the whole country, then what were the other reasons? I don't think it is necessary to go into intelligence reports. It would neither be fair to him nor to the judiciary.
In which case, Soli Sohrabuddin, I'm going to ask you, Soli, for a very brief answer. Is it now in the best interest of Mr. Subramaniam, as well as in the best interest of the Indian judiciary, that a line be drawn over this matter and it be forgotten?
Yes, line should be drawn, but what should not be forgotten is that the proposed appointee should not express lack of faith in the collegium. And Karan, there is only one thing I want to point out. The suggestion is Gopal was not suitable from the government's point of view because of very strong in the Sohrabuddin case. Rohinton Nariman, whose appointment has gone through, he was in a matter where I was opposing him. He made strong allegations about the Gujarat Lokayut Act and also allegations against Narendra Modi. That did not come in his way. Surely he went through. So this sort of thing, I think, is more speculation that because of his role as amicus curiae in the Sohrabuddin case, that was the main reason. I don't believe that.
All right, gentlemen.
Rohinton Nariman's case is an illustration.
All right, gentlemen, we've tried to answer all those critical questions that I said we would. We may not have given completely satisfactory answers. We certainly haven't in every case given unanimous answers, but we've aired the different possible answers, and hopefully that will help people not only put this issue in better perspective, but also understand the many issues and concerns that it raises. My apologies that Dushyant Dave wasn't able to join us. I'm afraid we simply couldn't get the OB link to him working.